I am so happy to welcome in this next guest because from day one I have felt so strongly about the George Zimmerman Trayvon Martin case, and I know the trial is going to start soon, and I'm hoping that George Zimmerman could get a fair trial, and I know that his attorney Mark O'Mara is top notch, and he joins us right now. Mark, thank you so much, sir, for taking the time. I really appreciate it.
Sure thing. Good afternoon. How you doing?
I'm doing well. My question to you is, how is George Zimmerman doing? I read a report yesterday that you had talked about that he had, gained a whole lot of weight, and it certainly can't be easy for him, all this waiting around and facing what he's facing.
Well, no, you've got a guy who did what he thought he had to do a year and 4 months ago in protecting his own life by having to take the life of another, and then he gets turned into what his moniker has been, which is the most hated man in America, and has to live in hiding for the past year and a half. And yeah, he's gained over 120 pounds. He's very stressed out, ready to get acquitted, but it's a very high pressure cooker here in Florida and throughout the nation about this case, and he's feeling some of that stress.
He's still at an unidentified location. He's still obviously, I presume, cannot walk around, leave the house, go out in public?
No, I'm not sure that he'll ever be able to, because were he to get acquitted, which we certainly plan on, then there's still going to be half the country or whatever percentage is going to be upset thinking he didn't get convicted of a crime he should have been. And if there's any anger that's still out there, it could easily be focused on him even after he's acquitted.
Yesterday, I think the attorney, Benjamin Crump, speaking after you spoke on one of the TV shows, called this a civil rights / equal justice case. Of course, the racial aspect here has been played up. But, there is no indication, not on the tapes, although NBC certainly gave it a try with doctor tapes at one point. Mm-hmm. There's absolutely no indication, and tell me if you agree. Well, let me ask you, does this case have anything, in your view, in George Zimmerman's view, to do with race?
Well, it just never had. I mean, even in the beginning when the FBI did their initial evaluation looking into whether or not George was acting as a racist in a way that violated Trayvon Martin's civil rights, they came back conclusively that he did not. Every one of the 40 witnesses they talked to, they found no evidence whatsoever of racism. So it has nothing to do with race. And if, in fact, this case is a civil rights case, then tell me what the result is. So if George gets acquitted, if the jury believes that George acted properly in self-defense and resisting force likely to cause great bodily injury, that's the statute. If the jury believes that, are you telling me that that is a loss for civil rights? And if so, how is that a loss for civil rights?
Yeah, no, that's a very good question, and I'm sure Benjamin Crump, I'd love to hear his answer. Mark, the judge made a ruling yesterday, several rulings yesterday. I mean, I know you're not going to, well, I'm not going to tell you how I feel about the judge so far. I just get an uneasy feeling. To me, and again, I'm not a lawyer, and I don't play one on the radio, but I do, tinker with kind of legal analysis from time to time in my own way. To me, this case isn't about, did he follow him? Should he have followed him? Did he precipitate the thing? It's what happened during the confrontation, and how could it not be relevant to what happened during that confrontation? Who started it? What was going on during it? If this guy, if Trayvon Martin has talked about in recent tweets, recent to that point, fighting, bloodying someone, doing drugs, about drugs, violence, a picture of a gun, how could all that, according to the judge, not be admissible in opening arguments?
Well, I'm okay, and I was the one who suggested early on in that hearing that the judge restrict us from openings. Because remember, openings is where you tell the jury, here's what I think you're going to hear. So I'm very okay with the judge saying, we don't want either one of you going places that this trial may not take us. So I'm okay with staying away from the idea of those incidences. All of what you just said is only going to become relevant if the state makes it relevant. If the state tries this case on just what happened, those 5 or 6 minutes that these two lives intersected, if we stay true to that, then most of the information out there, all the stuff they brought about George and all the stuff that's out there about Trayvon, the majority of that's probably not going to become relevant. Now, I will tell you the issue concerning his knowledge of fighting may well become relevant. But I'm very willing to wait until seeing how the state handles this case, and then we'll respond.
So you're saying if they continue to present Trayvon Martin, or not continue, but if they at trial present Trayvon Martin as Pierce Morgan has consistently, and most of the media, as a little boy skipping home with a bag of Skittles and an iced tea and an angel, then then that opens the door for the other evidence? Is that what you're saying?
Yes, if they present him as being some peaceful individual and not having any ability even to be aggressive, let's say, then I think that's going to open the door to the counter-arguments, because this is an adversary proceeding. If they bring it up, we get to respond to it, and then that will come in. If they don't go near that, then we most likely will not. There'll be no reason to.
All right, I got two more for you. We're talking to Mark O'Mara,
Sure.
the defense attorney for George Zimmerman here on the Steve Malzberg Show. This is not about, again, correct me if I'm wrong, this case is about what happened during the confrontation. It's not, it shouldn't be about should he have gotten out of the car, what did the police say to him, and of course they never told him not to. They said you don't need to do that, as if we listen to the tapes correctly. So isn't it just about what happened, the confrontation? Now, is it still self-defense if, and I'm not saying he did, because I don't believe he did, but if George Zimmerman, if the jurors think George Zimmerman started the actual fight or confrontation, not getting out of the car, but when they came together, through the first punch, let's say, do you still have a right to self-defense if you're on the bottom and your head's getting banged and you think you're going to die?
Yes, under that scenario, not that I agree with it, but under the scenario where George actually started the fight, he still has the right to self-defend if he evidences that he is retreating. And I would suggest that the voice on that tape, seemingly the person who was injured, George, it was his voice saying help, that would be a retreat, in my opinion. The jury could still say that he has the right to defend himself with deadly force against great bodily injury. But it goes even, of course, a step before that. The only person with injuries but for the fatal gunshot wound, the
Right.
only person with physical attack injuries is George Zimmerman.
Right. No, absolutely. Now, I see today that George Zimmerman, there's a couple of stories that he is going to want to take the stand. Is that something you guys have talked about already? Is that a decision that's been made? Is that something that will be made as the trial goes along? And, you know, do you advise at this point that he does take the stand?
Well, that was what was called sort of a plant. Somebody planted that story to try and get a response from us.
Okay.
Because we have not said anything about that. He's already given 4 or 5 statements about the events that night. He was voluntarily gave them, did everything the cops told him to do. So I think that information is going to get before a jury, and we'll always make the decision sort of dynamically as to whether or not he needs to testify, or if the state has even proven their case. We don't forget, you know, this case has sort of gone backwards in a lot of ways, that we need to justify our position. But the reality is the state has the undeniable and sole burden of disproving my client's self-defense beyond a reasonable doubt. If they don't do that, we don't have to put on a witness, a piece of paper, a client, or anything. The state has simply failed to do that.
Are you confident, and do you think that he can get, you know, these are people who couldn't help but watch the biased media reports over and over and over and over. Are you confident, and do you think that he can get a fair trial, especially in that jurisdiction?
You know, he's innocent, so the system should work, and he will be acquitted. I am very concerned, and the reason why I wanted an anonymous jury, I am extraordinarily concerned for the first time in 30 years of practice that the external pressures, the social pressures being thrown on top of this case, like a square peg in a round hole, are going to have effect on the jury's ability to properly hear the case. My concern is the juror who's got to go back home and say, yes, I'm one of the 6 who acquitted George Zimmerman, and not be subject to ridicule or anger or hatred or whatever may come from a proper verdict of acquittal.
Yeah, but have you requested a change of venue or no?
Not yet.
No.
We're going to try in Seminole County. You know, the problem with it is that we're certainly stuck to the 4 corners of Florida, and in today's day and age, there's nobody who doesn't hear about a case of this nature.
Right.
And if they haven't heard about it, I don't want them on my jury.
I hear you.
Living under a rock somewhere.
Mark, I know it's going to get very hectic and very busy, but we will call on you again, and good luck. And just let George Zimmerman know that there are certainly a lot of people out there that don't get a chance, that maybe he doesn't get to see them on the media, that believe in him and his innocence and would like to see a fair trial and get this done, and hopefully he could resume some kind of life.
Thanks very much. I appreciate it.
Thank you very much. Mark O'Mara, ladies and gentlemen, the defense attorney for George Zimmerman.